All right. Good afternoon, everybody. Welcome back to Attorney Live. We're asking Attorney Anything Live on Facebook. My name is Jamie O'Neill. I am actually one of the real estate associates at this firm. I'm actually a little new here. This is my first Ask an Attorney Anything, but today we're actually going to be covering force majeure clauses. So I know many people might know what those are. Some people may have no idea what in the world is that. That sounds like a really weird name. What is that for? So, force majeure is essentially a clause that is very common in contracts. Any type of contract, it can be in business contracts, it can be in an employment contract. It's very common within a real estate contract, which we are going to be covering today. Essentially, just as everybody probably knows, is attorneys like to use very funny Latin or French, apparently, words just to make it sound, of course, confusing. But in this situation, the force majeure essentially is French for superior force. So what that basically means and what that type of clause looks like in the legal world is that it refers to an event or circumstances that are beyond any party's control that makes it difficult or almost impossible or actually impossible for the other party or any party to actually comply with some sort of provision or deadline or timeline within a contract. So it's usually what it's typically there for is to make sure that there's some kind of protection for liability if another party or any party is unable to actually perform under the contract. Some examples that you can probably imagine would be war. It could be something natural disaster like a flood. Most commonly, people, especially in Florida, it could be a hurricane. It can be things like labor strikes. It can even be something like the pandemic or a pandemic. So back in 2020, obviously, when everybody was dealing with COVID and when that kind of struck the country by force, it became a huge issue whether or not COVID actually was considered would trigger force majeure under a contract. There's been case law on it and everything, but it does qualify just because it is a pandemic and things were closed, business was closed. Parties under contracts weren't able to actually comply with certain provisions under a contract. So it would trigger force majeure 99% of the time. In Florida, force majeure clauses can be a little broader than some other states. Other states like New York and some of the more northern states have very specific requirements of what is required to be in a force majeure clause. Now, my recommendation is always to lean on the side of caution and to be very specific, even though Florida doesn't require it to be very specific. They do case law, and the law does allow for a more broad interpretation of what has to be in a force majeure clause, but it's probably recommended that if you're going to include one in a contract or especially in a real estate contract, you want to make sure it's specific. Luckily, and we're going to cover one of the general real estate contracts in a little bit. It's very common that there is more specific language that is included to see what type of language as far as what kind of event triggers it. When does somebody have to actually comply with the provision under the contract or the requirement under the contract when the force majeure clause is triggered? But in general, you want to follow the following elements for a force majeure clause. You want to accurately define the force majeure event as precisely as possible. You also want to define the breach for which the contracted party would be excused from liability. Okay. You also want to try to add in there about defining the actual cause or effect connection between the force majeure event and the breach of the contract and the duties that are to actually be executed by the parties. Then finally, you also want to put in there or make sure that there's some sort of language about detailing the result or the outcome of what will follow with the excusal of the contracted duties due to the actual force majeure event. Okay. Like I said, it's very common in real estate contracts for those of you that either do real estate, whether you're an agent or you do real estate law, or maybe you are dealing with maybe wanting to sell your property or do some kind of contract for land or some kind of residential closing or commercial closing. The FAR contract, which is most people are using the FAR contract, or you're using some sort of authorized form from either the Association of Realtors or something, they're going to have a standard force majeure provision. Okay. If you look at the as-is residential contract for sale and purchase that the Florida realtors typically use, especially in this area, there is actually a force majeure provision. It is on section G. You'll typically find it on around page 8 of the MER contract. And essentially, I'm going to just read off, just because I can't really share it with you guys, but I'm going to just read off what is typically in here. So what it details is that the buyer and seller are not required to exercise or perform any right or obligation under the contract or be liable to each other for damages so long as performance or non-performance of the right or obligation or the availability of services, insurance, or required approvals essential to closing is disrupted, delayed, caused, or prevented by a force majeure event. Okay. Now, under the farmer or under the as-is contract, force majeure is actually defined. It's a defined term, and it means things like hurricane, flood, extreme weather, earthquakes, fires, or other acts of God, which those are typically what these types of provisions are called. A lot of people do refer to these as act of God, some crazy natural disaster or some kind of natural weather event. It's typically most of the time for people what is triggering this type of clause, but obviously other things like we discussed earlier with pandemics or labor strikes or things like that can also trigger a force majeure event. It can be, so it goes on to say that there's also unusual transportation delays, wars, insurrections, civil unrest, or acts of terrorism. There's all sorts of other things that are also defined on here. So this is a very specific clause that isn't detailed inside the as-is residential contract. Now, what happened is the force majeure event is deemed to have begun on the first day that the effect of the force majeure event prevents performance, non-performance, or the availability of services, insurance, or required approvals essential to closing. All time periods affected by the force majeure event no longer prevents performance under this contract, provided, however, I skipped a line. All time periods affected of the force majeure event, including closing date, will be extended a reasonable time up to 7 days after the force majeure event no longer prevents performance under the contract. Provided, however, if such force majeure event continues to prevent performance under the contract for more than 30 days beyond the closing date, then either party may terminate the contract by delivering written notice to the other, and the deposit shall be returned to the buyer. Now, I'm going to break some of that down. So let's try to use an example of something that probably happened, obviously, to many of you that we're dealing with, especially in the Central Florida or West Coast, actually all the way to the East Coast, pretty much in the central part of Florida last week when we were dealing with Hurricane Milton. So I'm sure a lot of people were dealing with issues with trying to close on a house. So we're going to focus on the real estate aspect of it. So many people might have needed to close on their house. Let's say the closing date was supposed to be on Thursday. Now, for those of you that were in this area, you know that Milton came through pretty much around Wednesday evening, early Thursday morning. So that affected a lot of people that had closings that were scheduled for that Thursday. So what does that mean for your clothing? What does that mean? If I don't close on Thursday, whether it's the seller or the buyer, people start getting very worried. What does that mean? Am I going to be in breach of my contract? Does that mean the seller can walk away? What does that mean? So under the force majeure provision, which is very important, that type of provision is in your real estate contract. What that allows for is because Hurricane Milton came through, it is a defined type of force majeure event. It is a hurricane. It was a named storm that then allows you, as the buyer and the seller, a reasonable amount of time to comply with whatever that deadline was under the contract. So, and for this example, we're going to use the closing date. So you're stuck with that closing date. That is the day you are absolutely supposed to deliver the property, and the buyer is supposed to be ready, willing, and able to close by that date. Okay, so let's say we were using last Thursday as the date that you were supposed to close. Now, you now get a reasonable amount of time, up to 7 days under the contract, which is the language that's included here, after the force majeure event no longer prevents performance. So in this particular example, if you're supposed to close Thursday, that's when Hurricane Milton rolled through. Now, most people, and I'm going to use our office actually as an example, were not able to actually go back and be back online, be back in their businesses, be back at work because of power or internet issues or different things that were caused or some kind of effect from the hurricane until the following Monday, which was this past Monday on the 14th. So what happens is you now get, under the contract and under the language that's there, you now get 7 days from the time of when the force majeure event is no longer affecting the performance. So if the first day, if you were supposed to close Thursday and then the hurricane comes through, it's the very first day that either party could try to comply with that provision. The closing date under the contract is now Monday, the 14th. You now get the 7 days starts ticking from that specific date. So for the 14th, you now get up to an additional 7 days to then comply and then close on the program. Okay. Now, sometimes what can happen is different people might have different opinions on whether or not the force majeure event has actually stopped or when has it actually allowed another party to prevent the actual closing from happening or the event under the contract from actually taking place. Now, it's very common for this example that we're using about the hurricane is you have a title company, for example. We also have our title company, Concierge Title, who does a lot of closings along with our law firm. We were not open because of the storm, because there was no power, there was no internet, and we didn't have any ability to actually conduct a closing until Monday on the 14th. If anybody had a closing that was scheduled during the time period of when the hurricane came through before the business closed, then neither party was able to perform, and even the title company cannot conduct the closing. For example, if the buyer might be saying, I'm ready to close and I didn't lose power, that doesn't mean that force majeure is not triggered under the contract, because the seller also cannot comply and neither party can truly really comply with the closing date, because you need the title company that's been chosen as the escrow agent to be actually open and be able to actually conduct the closing. So there's other things. It's not just basically one party or another in every situation. Sometimes it's actually, in this situation, it would have been a third party that could not actually allow either the buyer or the seller to comply with the contract and close on that date because there was an event like the hurricane that had prevented the closing or the contract from being performed in the way that it was actually intended to be performed under the language that was included for the closing date. Now, as you also heard me read from the contract, it also allows for up to 30 days under a real estate contract. You get 30 days to pass the closing date in order to, from this force majeure issue that's now caused a delay in the closing, it can be extended up to 30 days. Now, beyond the 30 days, you can you can elect to then terminate and the buyer can get their deposit back, but that's not absolutely required. There is absolutely no requirement for either party to then decide that they want to walk. Both parties could decide they still want to go forward with that real estate closing and go ahead and close on the property. But it's really up to, it is an ability that based on that particular force majeure event, that it does allow an out for the parties, given the natural disaster or pandemic or labor strike or whatever it is, war that could possibly prevent the actual contract from being complied with. So that way the liability is reduced or eliminated from the parties that would have normally had to comply. I'm going to see, I don't know if we have any questions. I'm going to just see if there's any questions here that I could maybe answer for anybody. All right. It doesn't look like we have any question. So I guess we will see you guys next time. Please make sure that you join us for our attorney lives that we try to hold at least weekly if we can. Obviously, barring no hurricanes that roll through here again. But thank you for joining. And obviously, if anybody ever has any questions, any real estate contract issues, or anything like that, I'm always here. Again, my name is Jamie O'Neill, and feel free to reach out to our firm if you guys have any questions, and we'd be happy to assist with any legal issues you guys might have, especially real estate related. So thank you.